Hello, everybody. Uh, Thanks for being here with us. We're coming back with your February employment law update. My name is Joseph Dickey. I got my law partner, the incredible Garrett Steck here, who has all your immigration knowledge needs. I'm just kind of here to try to see if I can give you a little tidbit of what I know, but that's why we got Garrett on. So we can make sure that you get all the things you need. Immigration has been a big thing that's been going on since the new administration came into play, and unfortunately, there's been some additional headlines, but it remains a focal point of the administration. It's a focal point right now in employment law. So today we're going to get started with Garrett talking about some employment-based immigration. We're also going to talk about ICE enforcement readiness. But first, let's talk about the firm. Hainsworth Sinkler Boyer, our firm, established 137 years ago. We're a full-service law firm with 5 offices, South Carolina and North Carolina. Charleston, Columbia, Greenville, Florence, and Raleigh. 120 plus attorneys, and we're continuing to grow. It was a great place to be. I wouldn't be happier, couldn't be happier anywhere else. So if you need anything from immigration, employment, corporate law, or anything else, please give one of us a call or any of our attorneys. With that, I'll turn it over to Garrett Steck.
All right. Good afternoon. Welcome to, again, this last presentation in February for those in the upstate. You don't have to go out to lunch. You can listen to me for half an hour and Joseph for half an hour to not go out in the rain. Again, before we get started, we'll address as many questions as we have. And if you want the slides or have anything specific, please feel free to reach out. Next slide, please. Next slide. So usually I come in and talk in February and try to introduce and remind people, if you employ any foreign workers, that there's an H-1B lottery held every March. This year, we got a whole lot more to talk about. As Joseph mentioned, there's a new administration that took office last January. Immigration was a primary pillar of the campaign, and there's been a lot of immigration changes over the course of the last year. So enforcement increased scrutiny, allowed DHS, which is USCIS, the administrative arm, ICE, which is the Immigration Customs Enforcement, which is the enforcement or police arm, CBP, Customs and Border Protection, and TSA, as well as DOS, which is embassies and consular posts worldwide, to try to work to deter fraud and detect aliens with potentially harmful intent so they can be prohibited from entering the U.S. or removed if they're already physically present. Again, not going to talk about really what you're seeing on the news. That's a lot of ICE activity, a lot of individual activity to a point. We're going to try to focus more on the business impacts. But with everything that's going on, there are changes. I start my day seeing if the administration has tweeted anything overnight. We have to basically look up online to see what's changing, because gone are the days where the rules are changed and promulgated through the Federal Register as they have been for the last 30 years. So with that being said, a lot of these changes do have impacts on local business, such as delay, government investigation, personnel issues, all of which leads to increased costs. So next slide. So today we could talk about a lot of things for probably the rest of the afternoon if you are all willing, but we're going to highlight just a few: social media vetting, travel bans, Real ID, just as an update, DOL Project Firewall, non-immigrant visa temporary worker changes to a point. A lot of that's going to be focused on the H-1B lottery and the changes there too next month. And then a brief comment on ICE HSI enforcement, which is Homeland Security investigation. That is the business side. Joseph's going to talk more, I think, on the ICE side as well. That being said, let's move on to social media vetting. So Big Brother is watching you. Yes, the government has invested heavily in AI-powered surveillance monitoring tools. There are over 55 million people in the United States that are foreigners or visa holders that come and go in and out of the country. This new social media or vetting, Immigration OS, Babel X, or 10, continuous vetting, searching all records, CVIS records for students, social media, message boards, online comments, criminal record checks, even the dark web, looking for violations or people that might come out against the government or do something contrary to the government's best interests. particular importance that this applies to all family members. So if you have an employee that is working for you in H-1B status, and there's family members, there might be a disgruntled high school student who may be into things that the parents aren't aware of. But basically, if the government comes across something that a child did online or a teenager did online, it could impact the visa status of the entire family. What they're also looking for is consistency across platforms and applications. Everybody back in my day used to embellish their resumes, their print resumes. Now, everything's on LinkedIn and electronic, but the government now is looking at the application we're filing, and then they're looking for social media to see if everything's consistent, because a lot of people embellish, good or bad. They may overinflate their title or their responsibilities. We had a gentleman who on Instagram said he was basically some sort of engineering manager. In reality, he was not. And we need to make sure that everything's consistent, because this immigration, again, is AI. It's not perfect. We just received an email earlier this week where an individual, this AI search, discovered that he had been arrested for a DUI 3 years ago. Well, 3 years ago, we handled this matter. The visa was canceled. The gentleman went back to his home country. We basically reapplied, explained what happened, showed the disposition, got a visa, and he's been working. Then out of the blue this week, his visa was canceled again because of an AI search. Presumably looking at his record, nothing's happened. This is going back again to the 2023 issue that we've already handled. Just for other neat stories, one of the universities had an individual whose student visa was canceled because he was caught fishing without a license. Another one had too many parking tickets. And then a third one was actually home for the summer break, lost his passport, applied for a new passport, had to get a new visa to come back and finish, to come back into the United States to finish his senior year in college. And the visa was denied because an AI search of his social media showed a picture of him at a tailgate function drinking a beer underage. So the AI is out there. Big Brother is watching you. I also make the comments that there are, ICE has, in most cities across the country, there are cameras now that are monitoring and looking for license plates and looking for traffic patterns. It's not just at the border anymore. They're looking on major interstates. I went and looked at one of the websites, and literally there's one probably a mile from my house. They're all over the country. It's a group out of Atlanta that's working with the government. So the government is monitoring both its own citizens and any foreign nationals. It leads to that social media vetting can lead to visa revocation, which in some instances mean status terminates immediately. That individual may have to leave stop employment and leave the country. And then also for the individuals, social media profiles must be made public as of this past December. So if there's any private Instagram, Facebook, any other sort of TikTok or anything, the government will not process an application if they can't search the social media. And then what does this happen? USCIS and consular visa processing, cancellation of appointments, and massive delay and disruption in the visa process. So what used to be people could leave on a Friday or Saturday, fly home over the weekend, attend a visa appointment in the morning on Monday, get their passport back with a new visa stamp and return the following weekend. Now we're seeing some people stuck in home countries for several weeks, if not months. And then also another change was that the government is mandating that individuals, unless you are resident in another country, you must visa process in your country of residency. So that's lots of changes, but again, to business, remind your employees, if you do employ any foreign nationals, that Big Brother is watching you. Next slide. Travel ban, pause of immigrant visa processing. So based on a culmination of 6 individual proclamations stemming from June through January of this year, there are partial and total travel bans that impact more than 110 countries worldwide. You can see a selection of some of the full suspension and partial suspension countries online on the slide. Just to put that into perspective, there's only 195 countries in the world. So more than half of the countries have some sort of immigration restriction. Obviously, you can see the bulk of those are Africa, the Middle East, but they do stretch from South America all the way up into Kazakhstan, as well as some in Asia. So next slide. So this travel ban, we have nationals who are subject to full suspension and those who are subject to partial suspension. Full suspension, people from the specific country may not enter the U.S. on specific visas or in some instances at all, with very narrow or limited exceptions, meaning any travel from these countries is almost impossible. Partial suspension, immigrant visas may not be processed due to concerns about public charge or security issues. A lot of these countries may not have passport standards that are up to modern country standards, meaning all the background and full vetting is not being accomplished. So the government is saying we're not allowing people to travel. We're not going to issue particular visa types. But what's interesting about these travel bans or pause of visa processing is that the government domestically is holding cases and not making decisions on applications filed by individuals for certain benefits from some of these countries. I use an example. We have a client who is from one of the full suspension countries, lived and grew up in another country, has entered the U.S. and has been working legally in the U.S. and is applying for a green card or extension of current status. And things are not being processed. Things are being held. We have a physician that's from one of the full suspension or temporary or partial suspension countries in Africa. And to put this into perspective, the government is slow with pretty much everything they do immigration-wise. And in order to get applications processed quickly, we have to apply or use premium processing, which is government extortion. You pay almost $3,000 to get something done in a few weeks rather than several months. Well, we paid for this extension 3 weeks ago, and the physician, like I said, is from a partial suspension, which we filed before the January proclamation. And now the government says, we're not giving you back your money, but we can't process the case. So beware if you're looking at premium processing, make sure where your beneficiary is located from. And then the other big interesting thing is that the government is requiring a bond for visitors to obtain a visa to enter the United States. And that bond can be anywhere from $5,000 to $15,000 per visa, per family member. Not for, so if somebody from, say, Nigeria wants to come to the United States to go to Disney World, they may have to post $20,000 bond for the family. That's been difficult to implement, but it is in effect. So next slide, please. So changing to Real ID, I get a kick out of this. Real ID, as of May 7th, 2025, has become mandatory, but it stemmed from the Real ID Act of 2005. So 20 plus years ago, I was at a meeting with the South Carolina DMV about immigration and driver's licenses and talking about Real ID, and the fact that I'm almost retiring and it just got effective is I find somewhat comical. Just for reference, it establishes minimum security standards for your driver's license and prohibits certain federal agencies from accepting a non-Real ID license or ID, and that means airport, domestic flights, enter a secure federal building, enter a military base or a nuclear facility. But if you're aware, if you don't have Real ID, there is now an alternative. You can pay $45 at the airport and go through TSA Confirm ID if you need to travel and have not yet updated your license. And then also there are certain other documents in lieu of a Real ID license that you can use, and that stems from a green card, a passport, and multiple military ID and some other documents that will work. But just FYI, it's the gold identified by the gold star on the license or ID. Kind of moving back, DOL Project Firewall was effective in September. This is basically a new enforcement initiative to, quote, safeguard the rights, wages, and job opportunities of highly skilled American workers by ensuring employers prioritize qualified Americans when making hiring decisions. So basically what Project Firewall is yet another AI software search that they're basically going to look into any employer that has sponsored a foreign national for employment, conducting, and then depending on what they find, will allow them to conduct investigations to ensure compliance, and that could basically result in increased salary, back wages, penalties, and suspension and debarment from any of these visa programs. This was just introduced, very little information, very secretive, but we do know that the government is basically looking at everything. We have a gentleman who is seeking a green card and has been in the United States for 15 years. And the government came back to us yesterday with basically an intent to deny, asking questions about the student's employment when he was in school in 2013. Things that just people think are long gone and of no relevance might be coming back, and they're looking, and that applies for employers as well. They could look at past practices, current employment compliance. Again, don't really know much about this because it's just started and there's really been no news, and no one has been investigated that we're aware of at this time. But the most important point is the last bullet point. Anything that is anything that's been determined to be potentially problematic, they can share their information with other government agencies. And that means specifically ICE, which we'll talk about in a minute, and what that could entail. So next slide. So we're talking about non-immigrant visa changes. Non-immigrant are your temporary visas. Again, the alphabet soup, they range from students to employees to medical to law enforcement to extraordinary ability athletes and entertainers. But non-immigrant is temporary, meaning that at some point, this individual can only remain in the US for a limited period of time. So one of the biggest changes occurred in September, requires payment of $100,000 that must actually to accompany an H-1B petition when filed, which means you have to pay the $100,000 to the government before you can file an H-1B petition on behalf of a foreign national that's outside the US. And if that petition is not approved, you lose that $100,000 in addition to all the other money that you spent on the H-1B petition, legal fees, translations, educational equivalencies, and application fees. So when that was introduced it was introduced on a Friday in September at basically 5 o'clock Eastern Standard Time, and created quite an uproar over the weekend. There were some subsequent clarifications, but at the end of the day, it really only applies to someone who is outside the United States. So it really doesn't impact people who are here, people who are changing status, people who are extending their status. It would only become an issue if the government could not make the change because someone was not eligible for the visa. The government could approve the visa, but say we're not going to extend the stay or we're not going to change the status. We'll approve the petition, but the individual will have to leave, go abroad, apply for the visa stamp in their home country, and come back. Then before they go to the appointment at the consulate, they'd have to show evidence of the payment of the fee. But otherwise, unless you have someone outside the country, it's really not applicable. We do have a client. We have 1 or 2 clients that are actually in process of paying this as we speak, which is somewhat a little bit surprising, but lots of justification for it to get someone with very, very, very unique experience. Next slide. This is sort of the big change for this year for H-1B purposes. And the reason I focus on H-1B visas more than some of the other employment-based visas is that most other employment-based visas require some sort of relationship between the company and the individual, i.e. someone has worked for a foreign company abroad and is being transferred into the United States. A company from abroad is invested into a new company in the US and they want to send somebody over. The H-1B visa is really the only visa that someone can come to the United States and go to school and apply for and start working without saying, oh, I worked for BMW in Germany or South Africa for 5 years. Now they're transferring me here, and then I'll get transferred to our China operations. The H-1B allows, generally somebody to, obtain employment authorization and start working without that prior employment relationship. So in years past, there's always an H-1B lottery for, basically recent history. And that's simply because there are only 85,000 H-1B visas available per year. 20,000 limited to advanced degree holders, 65,000 for everyone else. The average number or the average submission number for the last 5 years has been almost between 400 and 500,000 people applying for 85,000 visas. So there's always been a lottery, and that lottery has always been a random lottery with basically over the last few years about a 20% chance of being selected. So the change this year is show me the money. Updated random lottery is going to be changed to a weighted selection process based on the offered wage. Whatever the company is paying this foreign national or offering to pay if selected in the lottery, that number and that number alone is basically cross-referenced to the Department of Labor's occupational profile, job profiles, and wage profiles. And if it's a wage level 4 wage or higher, the individual will get 4 selections in the lottery. Whereas if it's a wage level 1, the individual will get 1 selection in the lottery. So presumably the highest salary is going to basically obtain visas this year, which kind of goes back to why one of my companies is paying the $100,000 because they know they're going to get a visa because this individual salary is pushing 7 figures. Then, so they're pretty confident, or we're pretty confident we'll be selected in the lottery with that wage level and, multiple selections. This is a little bit different from the LCA wage level, which is based on the minimum qualifications for the job, not the individual's qualifications, not preferred qualifications, but just the minimum qualifications for the job, which is good to note because the H-1B wage levels, it's a prevailing wage. You have to pay a certain wage level or wage floor to maintain H-1B status, and those wages just get adjusted annually. So it's separate and distinct. So it's possible to be a wage level 4 for the lottery and possibly even a wage level 2, 1 or 2 for the actual job. A point to note is that multiple work sites and or employers lowest wins. And what I mean by that is that, say, for example, we've traditionally, ever since COVID, there's a lot of people that work from home. So we always include the main work site and the work from home location. In some instances, those are close by, maybe an adjoining county at most. In other instances, there might be somebody that might be a few states over that primarily work from home, but then once a month they come to the corporate headquarters. So we've always usually included both to be approved locations of employment. Now it's for the wage for the lottery, it's the lowest wins. And we're kind of talking about, so say, for example, you have an office in New York City and a wage level, and the wage paid to the individual is $120,000, but that happens to correspond to a wage level 1 in New York City. But you also have a corporate office in South Carolina, say in Anderson, South Carolina. And the salary is not quite as high because the cost of living is a little bit different, but the wage paid in Anderson may be a wage level 2 or 3. But for the lottery, you default to wage level 1 based on lowest win rule, meaning New York is wage level 1 that controls over the Anderson wage level, which might be wage level 2 or 3. That also applies for multiple employers filing on behalf of the same employee. Again, even if there are 10 different employers filing, there's still the individual only gets entered into the lottery through one of them. He or she would not be potentially selected multiple times with multiple employers and be able to select which employer he or she wanted to work for. So definitely now this is going to be a very interesting year because, again, most of the H-1Bs have been utilized in the past, at least in my past, for a lot of younger workers out of school, undergraduate or graduate or relatively young in a career. That's when you're subject to the H-1B lottery. Once you have an H-1B visa and you want to change employers 2, 3, 5 years later, you're not subject to this. So it's going to be very interesting to see how this all plays out, but it is definitely making major changes this year. The lottery begins next month at 12 noon on March 4th and runs through March 19th at 12 noon. It is not just the simple registration as it's been in the past. Now it's taking increased review of the position, the wage, the location, the duties, And of course, with everything, all these changes, it's basically resulting in higher cost and a reduced chance of selection for recent graduates, or more importantly, small employers. When you've got somebody like Google or Meta or Apple that might be filing 1,000 H-1B registrations and they can afford to pay a higher salary, they may take the bulk of the H-1B visas this year. So we're going to see what happens.
Garrett, I want
Yes.
to jump in and ask a question. Is there, and it just might have been said, is there any contingency plan that small employers can look at for the lottery if they can't get it, or are they just, out of luck? Is it like because there are some employers, whether it be H-1B or it's the other seasonal
Yep.
lottery, that just, that's their business.
Yep.
And if
It's
they're
going to impact. It's going to impact people, employers, this year. I mean, the same thing as Jessica was mentioning. There are other programs that are also subject to quotas, annual quotas, and lotteries, specifically the unskilled H-2B program and the H-2A program. But this one for the wages specifically to an H. But like I said, I don't think that there's going to be enough wage level for registrants that are going to basically fulfill the lottery. I mean, I don't think there's going to be 85,000 people that are wage level 4. I could be wrong. So I do think it's still going to push down. What I think is going to impact is going to be more of the recent graduates, because by default, a lot of them are entry level 1 wages because they're all entry level jobs fresh out of school. Small companies, it's going to be interesting to see how it plays out, because in years past, small companies were almost subject to, the larger companies. If you're a small company, you had a person that interned for you from a university, an F status, they were with you for 3 years, you wanted to sponsor them for a visa so they could keep working. And it was the only application that you filed, it was one. Whereas again, as I said, Meta might file 1,000, knowing that, well, law of averages, we're going to get 200 to 300 applicants. We'll at least have 200 to 300 selections. So they can at least bank on the fact that they will receive selections, where the individual small employer filing one application may not receive any. So this might help, but again, small companies may not be paying the highest wages and they may be excluded on that route. So this year is going to be very, very interesting to see what happens. There is talk that there may be multiple lotteries because we do not have enough high wage paid positions or registrants. So we'll see what happens. Next slide. So another couple of things just that have happened in the last year. The USCIS is transitioning to an electronic payment system as of October. They are no longer accepting paper checks. It's either credit card or an ACH transfer only. What we have seen, a lot of times for a lot of clients, we try to pay the fees, and because we can keep track of things a lot better. But in some cases, individuals pay their fee, and we have one client that is older, maybe not as technologically savvy as some, and we used his credit card for the family application. We told them, this is going to be multiple charges. What is your credit limit? It's going to hit. So of course, when the USCIS processes the credit card application and the government basically sees multiple charges from the same entity for the same dollar amount, which would apply to each individual family member, they throw up a red flag, and the fraud department contacts the card holder, and this card holder has canceled his credit card twice on us. So that's one of the things which causes a lot of delay, because we can send an application to the government via FedEx overnight. It takes them 30 days to 6+ weeks to send it back if the credit cards don't go through. Same thing with ACH. If there's insufficient funds in the account, the application will not get processed. The government will not tell you why, and they will just send the entire application back, thus delaying things significantly. Another important change this year was the DHS ends the automatic extension of the employment authorization card. The employment authorization card is a red credit card or driver's license document that evidences employment authorization, that is not just limited to specific visa holders, i.e. students, H-4 spouses, DACA recipients, asylees. basically people who are pending a green card application. It is a document that shows that you're work authorized, and historically, if you apply in advance, there's an extension that was up to 540 days that you could continue to work based on that receipt notice and your expired card. There's ways to update the I-9 form with a temporary or interim authorization. Then when the card gets issued, it would be issued for 2 to 5 years. They're now limiting most EAD cards to less than 18 months. The issue is that you can only file 6 months in advance, but processing on most cases is taking 5 to 11 months or longer. So that could lead to unemployment. If someone has an EAD card and they file to renew or extend it, and they don't receive the new EAD card before the current EAD card expires, they can no longer work. So that is something that you might need to be aware of. But it's not, in this case, not applicable to STEM. STEM was never had a 540-day automatic extension because generally that would almost encompass the entire validity period. So students is really the only category now that has that flexibility. If somebody, and it's not initial, it's only an extension and only for the STEM extension. So that being said, that's something to watch out for. Last slide, please, for me, and then we'll turn it over to Joseph. And this will kind of lead into what Joseph's going to talk about, but enforcement. I mean, we've all seen the news on TV. Apparently ICE is a new police military force, glasses, faces covered, no cameras. That's more on the true enforcement side, which is what, protecting the border, looking for illegals, looking for criminals. HSI is the business side. It's ICE, but it's Homeland Security investigations. That is the business side of the enforcement mechanism. And that's basically looking at site visits, which, if there's a large, construction project, there might be multiple contractors with multiple people. And, someone calls up and tips off, ICE and says, hey, there's just a whole bunch of foreigners working on that project. Or it could be a disgruntled person who his bid was not accepted and said, hey, that project's got a whole bunch of illegal people. You saw this several months ago in Savannah, where the Hyundai battery plant was being constructed. And basically the government came on site, rounded up everybody, including a lot of Koreans that actually had valid status, and put them into lockup for a period of time before ultimately sending a lot of them home. Audits can also be conducted via subpoena. We've had clients that just received a FedEx in the mail, which basically said, you've got 72 hours to turn over all of your I-9 records, all of your W-2 records, all of your 1099 records, all of your tax returns, and all of your company ownership information. And that just randomly showed up in the mail. South Carolina, LLR does E-Verify compliance audits that actually pop up from time to time. They're not very thorough, but they do pop up from time to time. And it's basically just to make sure, for most cases, that, believe it or not, even in 2026, I've had a client recently that was not even aware that E-Verify was a thing. A small mom and pop type business had no idea that they were required to E-Verify, register and use E-Verify. And again, this is separate from the ICE enforcement in communities. And then the point that I'm going to just leave you with is that this is where it's becoming very interesting with all this enforcement, is that when clients have, properly filed documents and have been following the same policies and procedures that have been in place for 20 plus years, in some cases, the government is basically arresting people while they're coming to the USCIS offices to provide biometrics or for their interviews. There was a big push around Thanksgiving where families would show up for their immigration interviews, some married to U.S. citizens with U.S.-born children. They separate the family members and then they arrest the spouse and send the spouse abroad. Same people basically hiding in cars at Home Depot looking for certain people. They hide in cars when people are lining up in the morning to enter the USCIS office for interviews, to provide biometrics, to ask questions. So the big thing right now is that we're looking at, with all this surveillance, with all the enforcement mechanisms, with all the potential delay and cost, the one thing we are basically recommending is that people be very careful if they're traveling internationally. Be aware that if they travel internationally, they may not come back, or it may be several weeks or months before they can come back. We're also asking that despite what we do, despite what you do as an employer, immigration is still ultimately the individual's responsibility. Someone could travel over the weekend. We had a client that all of a sudden went to Mexico over the weekend, came back into Charlotte, was arrested for something that happened 10 years prior, and he was deported. And no one at the employer site even knew he had left the United States. They just all of a sudden he never showed up for work for 3 or 4 days, and then finally got an email from halfway around the world saying, I'm in trouble. So, but at the end of the day, when an individual travels, they need to look and maintain their I-94s. They need to maintain their status, because if something happens and they fall out of status, they work without authorization, that could lead to this AI background search thing where they basically lose their ability to stay in the US and continue working. That impacts the individual, the family, but also the employer. So again, watch travel, prepare in advance, tell the individuals that they ultimately need to be responsible and careful and should carry identification with them that proves that they're here legally. So that being said, I think for time that's left, Joseph's going to talk about the other aspect. When ICE comes knocking at your door or your employee gets arrested.
Yes, thanks, Garrett. And just to follow up on something that you said about the I-9 and the E-Verify, if you don't think the government's looking at the smaller employers, there was a time I ran my own law firm and I got fined for I-9.
It is out there. We've had large clients and we've had small clients. The one thing to remember is that even with all the new money that's being funneled to DHS, there still are not that many ICE agents in the state of South Carolina. It's one thing to look on, the TV and what was it, Minneapolis, and they were, almost look like army marching, but that's a different side. The HSI group in South Carolina historically has been 6 to 8 people that were responsible for not only investigating randomly, but also following up on leads and following up on issues where they may have gotten from justice or somebody or FBI would say, hey, we think this person's in a cartel and we think they're laundering money and we think that they're working at your facility trying to just be, very, very casual. So then they come in. So, 8 people, the odds of being audited have been historically somewhat low. However, it's increasing now because the government's utilizing and spending a lot of money with this AI leverage. So they're trying to do a lot more with less resources and try to let the computers do it. And as I said earlier, losing your visa status because you were fishing without a license, that's really not in the current regulations. That's just AI saying that with interpreting or inferring that was a criminal action and then pushing them into a certain category. So that being said, I wouldn't lose sleep over an I-9 audit, but I sure as heck would make sure that if you're mandated to use E-Verify, that you're registered in using it and your I-9 compliance is up to date. Your hiring records, especially with foreign nationals that have status that changes a lot, and you're re-verifying using the correct portion of the old form or the new supplement form, and that if the government showed up, you would feel comfortable releasing your documents and records and saying, yeah, there's some hiccups here. We've done an internal audit, but you feel comfortable. If you don't have I-9s or you're trying to push all your compliance to 1099 employees, then you might have something to worry about. But that being said.
Right. And I'll just say again, preparation is going to be the key for all this, especially if you're running a business or have a company that employs a lot of foreign nationals. Just as you would look at your employee handbook and maybe your compensation policies annually for internal privilege audit, you should do that for your I-9s, your policies and practices. And as we get into a little bit here near the end of the webinar, if you have, business or operations where you might be subject to ICE visits, raids or whatnot, evaluating your response team, your response plan, or just any of your policies and protocols that you have in relation to that. So if and when the time comes, you're ready. I know my plan usually is to call Garrett. So I hope that y'all's plan can be that too. So with that, let's get into it. We don't have too much longer in the webinar, but I don't have much. I'm just going to kind of go over certain things that have been going on, just kind of differentiate between the ICE enforcement actions, some things you can do to prevent, to mitigate risk, steps to take if you have ICE showing up at your job site. Um, Training, some best practices, but some other considerations as well. So we'll go to the next slide where we're talking about the different enforcement actions, which are audits, I-9 audits. And like Garrett said, these are referring to your onboarding documents, your employee eligibility verification forms. It's required for you to employ people that are legally authorized to work in the U.S. Failure to do so can result in fines and other penalties. Again, I think Garrett covered this well. This applies to employers. Maybe you might have one employee. You could have 2,000 employees. This is a requirement. You got site visits. These can occur when you have H-1B or L-1 visa programs. We've had a client that had site visit, even a government employer that's had site visits regarding their use of H-1B or other visa programs and their compliance with the same. This is something that you should go over with your counsel, especially now with the increase in enforcement. These programs or misuse of these programs can lead you into big trouble. Some of the issues can certainly translate into criminal ramifications and take you out the civil realm. So this is something to be very important. Always, if there's a question, reach out to your immigration counsel. I would recommend you keep consistent immigration counsel in doing so as well. I know different lawyers might give different opinions, but you when it comes to these immigration type issues, I would recommend, I think we both would recommend that you keep consistent counsel that's advising you and that you can trust, and that's part of your team, which HSB certainly is. Lastly, you got ICE raids, and that's the thing that gets publicized and you see. ICE agents may come on the site. They might have some reason to believe there's, like Garrett said, people that are there unlawfully. There's a operation going on or something or other, and they will come in and they're trying to, apprehend people and find violations. Now, just because they come, that doesn't mean that, they have carte blanche access to your files, your site, your people. But we definitely suggest you need to comply, but there are things you can kind of do and look at. You go to the next slide. Just looking at where are we at? Oh, we're on allowed areas. Okay, so let's talk about allowed areas if you have a raid that happens at ICE. You have public areas. If there is a raid, ICE can come to any area, public area. They have a right to enter any public area that the ordinary member of public can enter. So examples could include dining areas and restaurants, parking lots, lobbies, waiting areas. We've had this situation come up with a client, a healthcare client, and what we kind of looked at is, well, the ICE agents can come into the lobby, waiting area, but you can't come into exam rooms. If there's a patient in an exam room, ICE cannot go into the exam room. That's not open to the public. So it leads to some interesting situations where you're seeing, and nowadays with some of our healthcare clients, patients canceling appointments, a significant drop in patients, especially in the FQHC world, community health area. You're seeing that because people don't feel safe to come get their healthcare. As far as non-public areas, or what I would designate private areas, ICE does not have that right to go into those areas unless they have a judicial subpoena, a warrant that is signed by a judge allowing them to go into that area. Now, let's talk about the warrant. You got judicial warrants and you got administrative warrant. The judicial warrant obviously comes from a judge, district judge, state court judge. And it specifies, let's say you could come into Hainsworth Singular Board, you can go into Garrett Steck's office, you can go into Joseph Dickey's office. That does not mean you can go into every attorney's office. Now, ICE agents might try to say that, well, we have the judicial warrant, we can go anywhere. No. So our recommendation, if that were to happen, obviously request the copy of the warrant, look at it, copy it, picture it, send it to your counsel, and govern yourself accordingly on your response. Be respectful, of course. I mean, we see we don't want to have any trouble with the federal government, but they do have limitations. They do have limitations on things on where they can go. So if we go to the next slide. Yeah, and that's what we were just talking about. Now let's talk about the administrative warrant. Administrative warrant easily obtained by can be easily obtained by ICE, but it does not give ICE authority to enter non-public spaces to carry out arrests. If you are presented with an administrative warrant, we would probably recommend that you consider all your legal interests. I think you can request the ICE delay. You can delay producing documents. You can just consider all your options. It's not the same practical effect as the judicial warrant that's presented. Now, the administrative warrant does not come from the judge. It would come from the enforcement authorities, DHS or the agency issuing, and it would come for a site visit or something of the nature. But the difference is the judicial warrant has more enforcement power and gives ICE agent more access versus the administrative warrant. So I think we've been talking about these things. I want to kind of get to, let's go to the slide where we were talking about, I guess, preparation for a visit or a raid, because I want to make sure we're talking about that. And we'll give you an updated version of this presentation when we get later when we get done, because I think we have some updates we can put in there. So if you think you might get a raid, or you just think you might be susceptible to the raid, we definitely suggest you have a plan. Obviously, get in contact with counsel, get in contact with our employment team, Garrett, immigration counsel, or whoever your people might be, your team may be, and start getting prepared. When we've had this situation with a client, we've told them to designate a point of contact, whoever that may be, whether that's a receptionist or front desk, and then you designate a member of a supervisor, manager, or another person on the leadership team that can be there and be the designated spokesperson for to communicate with ICE, whether that be you can use that to be the legal counsel. But I think they have to file, Garrett, if I'm not mistaken, if you have outside legal counsel that's doing that, they need to file a internal form with ICE or at least present that to them to be the outside counsel that communicates with them on a visit or on a raid.
Yes.
Okay. But if that's not a legal counsel, just have a senior leader or a senior manager that's going to be that point of communication. Make sure that they have a protocol that they're going to follow and that you have run through and trained your employees on. They need to know what's the public area. They need to know what's private area. They need to know that request for the warrant, review the warrant, forward it to legal counsel, contact legal counsel as appropriate. They need to ensure that employees still maintain their rights, and you need to ensure that you don't take any action as the employer against any employees that might have taken whatever action that exercise their rights or whatever action they deemed appropriate for them, that would be deemed retaliatory or otherwise in violation of other laws, whether that be the National Labor Relations Act or any federal discrimination laws. So I'm going to go to the next slide. We've talked about what ICE raid is, but yeah, so we've seen the people on TV, news. We've seen people, elsewhere. ICE raid, ICE agent go on a work site. It's usually a surprise. They're marked as federal agents. Sometimes they carry guns. They have the vest, the mask, and things. But they sometimes have other law enforcement agencies or federal agencies accompanying them. So next slide. Okay, and we went through this, and we go to the next slide. Yeah. So let's talk about we kind of talked about this, but we're going to get more down specific. If ICE is there, once ICE is there, again, you have your protocol, you have your response plan. Your designated communicator staff should engage with ICE. And engage doesn't mean Mortal Kombat or anything, but just touch base, communicate. What's your documentation? Why are you here? What's the warrant? Look at it. Escort them to designate the areas, mark the areas that are private, that they cannot go unless the judicial warrant provides such. If they are requesting documents, whether this has been a NOI, a notice of inspection that you've gotten and it's 3 days after, or if this is a delay, they are requesting documents that are lawful from you and it's a lawful request and you're providing them. You need to, create a journal of what they are taking, what they have requested, who are they speaking with, so you can understand what's going on and you can debrief with counsel after the raid. Most importantly, based on the increased enforcement things, I think it's important to be calm, be cooperative. You definitely don't want to be noted for obstructing the federal agencies or agents. There have been situations where there have been employers, senior leaders, even lawyers that have been, detained for their actions, basically saying that they were obstructing. So the importance of having this plan and protocol response plan in place is just very important. It's very important to train on it. If you're susceptible to it, it's very important to your employees understand it, understand the ramifications. Garrett, you got anything to add to that?
No, I was just going to just remind everybody that there's the difference. A raid is a raid, and they typically come in with guns drawn, multiple agents, vans, cars, and it's a true law enforcement action. An HSI site audit or investigation is generally one officer coming into the office, generally leaving you with a request for documents in a 72-hour turnaround period. Nice, polite, not asking to go look and explore your office. But generally, you're responsive to that individual. I'll make a quick comment that happened long, long ago. It was not my client to begin with. I get a call and said, we just had ICE show up. And this particular client, ICE came in with a U-Haul truck and took all the personnel records because all the personnel records, all the I-9 records and everything was all commingled. ICE came in with the truck and hand truck and took all the file cabinets that had everything. So in addition to that causing major problems because they had no record of what they gave or released to the government, they didn't have a lot of their records. Ultimately, they were fined for, I think, $50,000 plus, if I recall, for I-9 violations for I-9s that should have been basically removed or terminated or destroyed in the 1 and 3 year window. And they said, well, you gave them to us. They all had problems, so we're just putting them into the penalty matrix, but they should have destroyed those. So the thing is, segregate your records for I-9 purposes. Do not turn over unless asked for specific information. Only release what is needed to respond. But they're not going to come in unless it's a site raid with guns drawn, demanding you guys do this. I mean, they're fairly, street clothes. They can present a badge. They probably may have a gun on their hip in a holster, but they're not coming in tactile gear, demanding and screaming at you. That's more on the raid situation. So that's a little more rare than just the site audits. So just be aware of the difference.
Indeed. I was liking the site visit to like DOL coming in on labor investigation or things now, which I believe we all would still be of the same mindset. We don't want the federal government coming on to the work site. In any event, we don't want them to come there. And so it's just good to have training and our protocols in there. We're getting down to the end. I want to leave time for a little bit of questions. So I want to kind of just go to some additional considerations that we have, which I kind of mentioned with regards to, ICE raids or other things. Be mindful of Section 7 of the National Labor Relations Act. With regards to Section 7, employees that might decide to stay out of work, because they know something's coming or take other action, be careful not to retaliate against them. If there's no misconduct that has occurred other than them staying out of work, they've used leave. That could be considered an adverse action if you take some kind of personnel action against them. That could be an adverse action in violation of some of the federal discrimination laws. But it also could be considered, and this is an argument that's been made, that it could be infringing upon their ability to, I guess, come together, act together, unionize, or what have you about their employee rights or their job under the National Labor Relations Act. So just be mindful of that. Be mindful of any criminal violations that you could be subject to. You don't want to be considered as taking actions that would be deemed harboring or trying to enable employees to violate the immigration laws. And so, that's why we say be calm, cooperate, but have a protocol, have a plan in place, have legal counsel as your partner. Should you have these site visits or raids or any other enforcement action that might come to you. Other issues, wait an hour, these things that you might not think of. Continued employment of foreign individuals or not unlawful immigrants that might be in the country and employed, which will go back to your I-9 compliance. But your continued employment of the same could lead you to some wage and hour violations with overtime paying those individuals, and even in the workers' comp realm here in South Carolina, there's a cap. Should you have an undocumented worker or unlawful individual worker and they have a work-related injury, there are some caps there with regards to damages that will happen should there be an injury. And so there's a lot of things that can come out of these enforcement actions, and a lot of things to be mindful of and to debrief and take stock of if it should this happen to you. But we're here to assist and provide guidance and help you develop your protocols and procedures, policies, or response plan should these things occur. So with that, I know we got about 2 to 3 minutes left. So if there are any questions that we can try to answer, or if there's any topics to discuss, we're here. Kaylee, if not, then I think me and Garrett will say thank you for deciding to spend your lunch hour with us. In Columbia, it's a rainy day, but I hope that we made your day bright with our lovely faces and this exhilarating topic. So thank you for being here. As always, we're here. There's our contact information. Feel free to call us. Garrett's in our Greenville office. I'm in the Columbia office. If we can ever help you, please give us a call. Thank you again for being here. Thank you for your continued support. We look forward to seeing y'all in March.
Thanks. Bye-bye.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.